Florida's new DEI ban, Senate Bill 1134. What it means for counties and grants in 2026. Florida's Senate Bill 1134 bans state and local governments from funding or promoting diversity, equity, and inclusion initiatives. Signed into law on April 23, 2026, and effective January 1, 2027. Also known as the Official Actions of Local Governments Act. This law prohibits DEI funding, promotion, and training for all state agencies, counties, municipalities, and special districts. The law defines DEI broadly, creating direct conflicts with federal grants that include equity or diversity requirements. County officials must understand the law's provisions, penalties, and compliance strategies before the January 1, 2027 effective date. You can find the full text at flsenate.gov. The companion bill is House Bill 1001. Now let's examine what SB 1134 actually is. SB 1134 is a Florida state law that redefines and restricts how local governments may address diversity, equity, and inclusion matters across all operations. The law defines DEI as manipulating or influencing the composition of employees with reference to race, color, sex, ethnicity, gender identity, or sexual orientation, except for lawful anti-discrimination compliance. It applies to all state agencies, counties, municipalities, and special districts across Florida without exception. The law's official title is the Official Actions of Local Governments, and the full text is available on the Florida Senate website at lflsenate.gov. SB 1134 contains 7 core prohibitions that directly affect county operations and government spending. First, no DEI funding. Counties may not spend taxpayer money on DEI programs, offices, or staff positions of any kind. Second, no DEI promotion. Government entities may not promote DEI in any official capacity or public communications. Third, local DEI ordinances must be repealed. Any existing county resolution establishing DEI must be nullified. Fourth, private right of action. Any individual can sue a government entity for engaging in prohibited DEI activity. And fifth, the governor can remove elected officials found to be promoting DEI, which is defined as malfeasance in office. Counties across Florida must fundamentally restructure their approach to DEI-related activities while continuing core government services. Counties must cease DEI program funding, DEI staff positions, DEI training, and funding to community organizations with DEI or LGBTQ missions. However, counties can continue merit-based hiring, compliance with federal anti-discrimination laws including Title VI and Title VII, and neutral community services. County attorneys should review all policies for SB 1134 compliance before the January 1, 2027 effective date. SB 1134 creates a direct conflict with many federal grants that include DEI, equity, or diversity requirements in their scoring or program terms. Here's a real example. Palm Beach County was denied a federal HUD grant for AC repairs because the building was leased by an LGBTQ community center, with the state citing SB 1134. Federal grants from HUD, the Department of Transportation, Health and Human Services, and the Department of Education include equity requirements that conflict with SB 1134's DEI ban. Counties must evaluate each federal grant individually for DEI-related terms before applying and may need to decline funding. Counties are caught between conflicting federal and state requirements, a constitutional question that has not yet been resolved by courts. Federal law through Title VI, Title IX various grant conditions requires certain equity measures, but SB 1134 bans DEI initiatives at the state level. Legal experts debate whether SB 1134 violates the Supremacy Clause, found in Article 6 of the U.S. Constitution, but no court has ruled on this yet. In practice, some counties accept federal grants but remove DEI branding. Others decline grants with explicit DEI terms, and others use nonprofit partners. Counties have until January 1, 2027 to come into full compliance. The transition period is critical for planning. SB 1134 was signed into law on April 23, 2026, beginning the transition period for counties to audit and restructure programs. The effective date is January 1, 2027. All DEI programs, contracts, and ordinances must be wound down by December 31, 2026. Notably, a new governor takes office in January 2027 as Governor DeSantis is term limited. This could change enforcement posture and priorities. The consequences of non-compliance with SB 1134 are severe and multidimensional for counties and their officials. First, private lawsuits. Any individual can sue a county for engaging in DEI, and taxpayer dollars fund the defense regardless of the outcome. Second, removal from office. The governor can remove elected officials, including county commissioners, for malfeasance related to DEI promotion. And third, loss of state funding and attorneys' fees for prevailing plaintiffs create powerful financial disincentives against noncompliance. Here's a practical 7-step roadmap for county compliance with SB 1134 before the January 1, 2027 effective date. Step 1. Audit all county programs, contracts, and grants for any DEI components. Identify everything that must change. Step 2. Eliminate DEI dedicated positions and offices. Reassign staff to general compliance or HR roles. Step 3. Revise all employee training. Replace DEI content with legally compliant anti-discrimination training. Step 4. Review every grant application for DEI or equity terms. Decide whether to accept with modifications or decline. Steps 5 through 7. Work with your county attorney, document everything, and engage with the Florida Association of Counties. Legal experts have identified potential workarounds, but none have been tested in court, and each carries legal risk. First, merit-based hiring without DEI branding is explicitly allowed. Focus on neutral, legally compliant recruitment practices. Second, nonprofit channeling. Shift community program funding through 501(c)(3) organizations that operate independently from the county. Third, constitutional challenges are expected on First Amendment and equal protection grounds. Monitor court developments closely. And fourth, the 2027 gubernatorial election may change enforcement posture. A new administration could take a different approach. To summarize, every county leader in Florida needs to understand these critical points about SB 1134. SB 1134 bans county DEI programs effective January 1, 2027, with full compliance required by that date. Federal grants with DEI requirements are now a legal minefield. Evaluate each opportunity individually. The Palm Beach County HUD grant denial is a real precedent showing how the law is already being applied. Enforcement comes through private lawsuits, potential removal from office, and loss of state funding. Workarounds exist, but carry legal risk. Consult your county attorney for specific legal advice. Primary sources include the Florida Senate website at flsenate.gov, Florida Politics, the Palm Beach Post, Equality Florida, and the National League of Cities. This presentation is for educational purposes only. Please consult your county attorney for legal advice.